Hi guys, it's Houston immigration attorney Pegah Rahgozar. Welcome back for another episode of Wednesday Wisdom with Pegah. I apologize, last week we had last minute technical difficulties and so I wasn't able to go on to Facebook Live, but we're back nonetheless. A little bit about the Rahgozar law firm. Our principal office is located in Houston, Texas, but we do take cases from all across the U.S. and outside the U.S. advising on immigration laws. Our office phone number is 832-792-3636. And you can learn more about this topic and other topics as well as about me by visiting our website at www.rahgozarlaw.com. So as many of you guys are aware, the government shutdown did end Friday, January 25th, 2019, and the government has been funded all the way through February 15, 2019, until a final resolution is reached between President Trump and Congress. And that's regarding immigration and the border wall issue, and whether the border wall will indeed be funded or not, which is what also President Trump mentioned in his State of the Union address last night. So as far as the government shutdown goes, if they do not reach a resolution by February 15th, that means agencies like Immigration Court under the Department of Justice, those will likely be closed if the government is not funded. Those cases will once again be backlogged and pushed back. So just continue to stay alert if you do have hearings coming up with Immigration Court. As far as USCIS goes, because those fees, because your fees fund USCIS, they do continue to process your cases. They do take appointments for InfoPass appointments, and they do continue to see you for your interviews. So those you don't want to miss. Also, Border Patrol and ICE, because they're essential to national security, they also remain open and active. Even if the employees are not funded and not paid, they're still doing their job. Now, moving on to today's topic, which is about domestic violence and immigration benefits and whether you qualify for a green card based on being a victim of domestic violence. Before I dive in, as usual, I'd like to inform you that any information discussed in today's video is for informational purposes only, and it should not be construed as legal advice. Every case is different, and because immigration is a fact-intensive area of the law, you should definitely seek proper legal advice from an experienced immigration attorney before filing any sort of application with immigration. If you are in an abusive relationship with a U.S. citizen or lawful permanent resident spouse, or you live with an abusive parent or child who is a U.S. citizen, you may have rights to apply for a green card all on your own as a self-petitioner under the VAWA program. So what is the VAWA program? VAWA stands for Violence Against Women Act, which was implemented back in 1994, and it allows physically or emotionally abused immigrants to petition for legal status in the U.S. without actually having to rely on sponsorship from a U.S. citizen or resident spouse, parent, or child. Now, despite the name VAWA, which stands, like I said, for Violence Against Women Act, this is actually available to both women and men. So we do have clients who are male victims of domestic violence. So it's not unusual for men to also petition for VAWA. Basically, these individuals have experienced either physical or emotional abuse or who have been subject to battery and extreme cruelty. And VAWA provides an immigration option to gain work authorization as well as permanent residency and obtaining a green card. And this can also be raised if you are facing deportation proceedings. There's also a different form of relief for individuals to file for VAWA when they're facing removal. If you're in the U.S. without legal status or you have temporary status and you feel trapped in an abusive relationship or a violent relationship, then this might be an option for you. But you do need to speak with an immigration attorney promptly to see if you qualify, because these cases are not only sensitive in nature, but also they're time sensitive in terms of eligibility for filing for VAWA with USCIS. So usually you want to speak promptly if you think that you do qualify. In some cases, the individual may also be eligible to apply from outside the U.S. to gain permanent residency on their own, but they must meet certain requirements. The exception to file for VAWA when you're outside the U.S. is one of the three following things. Either your abuser is a U.S. employee, U.S. government employee, or the abuser is a member of the armed forces, or you suffered the battery or extreme cruelty while you were living in the U.S. with your abuser. Under these conditions, you might be eligible to apply even if you reside currently abroad. If you do qualify, or if you have questions about whether you qualify, whether it's inside the U.S. or outside the U.S. for VAWA, then please contact our office at 832-792-3636 and make an appointment to discuss your case. As I mentioned, these cases are very sensitive. They're complex and require a lot of in-depth analysis and document gathering to present a successful case. Now, the basic eligibilities for VAWA are as follows. First is that you suffered physical abuse or battery or severe emotional or psychological abuse at the hands of your U.S. citizen or permanent resident abuser. And as mentioned, these could include spouse, children, or parents. That you resided with your abuser and that you can prove that you have a relationship with them. So residing, obviously, that you cohabitate in the same household. So you have some sort of documentation to show both names on it, maybe a lease or something. You can also prove your relationship to them. So if they're your spouse, maybe a marriage license, or some sort of indication that you guys do have a marital relationship, even if it's common law in a state that is recognizing common law. Or if it's your parent or child, of course, birth certificates that contain that information. You also have to prove that they're either a U.S. citizen or a permanent resident. So if they're a U.S. citizen, a birth certificate of them being born in the U.S., or if they have a U.S. passport, or if they're a permanent resident, a copy of their green card would help prove their status. You also have to show that you're a person of good moral character. Now, a lot of times for victims of violence, in this particular case, domestic violence, certain grounds that make you ineligible for most other immigration cases, under VAWA, they may be, USCIS may be able to waive those grounds. It just depends on each case, but generally you will have to show that you're a person of good moral character. Other eligibilities that you might fall under is if your child was the victim of abuse at the hands of a U.S. citizen or resident abuser, and you're the immigrant parent, you can qualify to file together with your child. Also, if you're a parent of a U.S. citizen child who's over the age of 21 years of age who has abused you, you also can qualify for VAWA. In cases of marriage to a U.S. citizen or resident abuser, you can file whether or not you currently reside with your abuser. So whether you live with them or not, you might still be eligible. And you can still file without them even knowing that you filed by using a safe address. USCIS allows for that. For VAWA, however, when it comes to marriage, if you do end up divorcing your abuser or your abuser ends up passing away, then you have to file for VAWA within 2 years of that divorce or death of the abuser. That's very crucial. That's why it's very time sensitive in those situations. You can also qualify to file for VAWA within 2 years if your abusive spouse, who's a U.S. citizen or resident, loses their status, I apologize, based on domestic violence. You can also qualify to file for VAWA if you believe that you were legally married to a U.S. citizen or resident abuser, but the marriage was not legitimate due to that person being maybe married to another person while they were married to you, basically committing bigamy. If you believe that you were legally married, you can still qualify to file for VAWA. So some examples for a battery or extreme cruelty include the following. This is not an exhaustive list, but these are things that you can look out for as a way to get started to see if you do, in fact, meet the requirements for a VAWA. But things like forceful detention, which results in physical or mental abuse, psychological or sexual abuse, including rape, molestation, or forced prostitution, homicide or the threat of homicide, stalking, aggravated assault, or other continuous patterns of emotional or physical abuse or violence. Once again, this is not an exhaustive list, so you should definitely consult with an experienced immigration attorney to further document any forms of abuse or battery that or extreme cruelty that you may have or are suffering from. What can you do if you qualify for VAWA? Well, depending on your case, you can either file the initial petition and then wait for it to be approved before filing for a green card, or if you're eligible in certain cases, you can concurrently file the VAWA petition together with the green card petition at the same time. And what are some of the benefits of VAWA? If you indeed are eligible to file for VAWA with USCIS and your case gets approved, you do get work authorization and you do get a green card. And you'll never have to fear your abuser knowing about it or ever being deported from the US if you are eligible to receive VAWA and receiving those benefits. If you feel that you do meet the eligibility requirements and have suffered battery or extreme cruelty, please contact our office at 832-792-3636. Make an appointment so we can discuss your case. What happens if you qualify for VAWA but you're facing deportation proceedings? Well, if you face deportation proceedings, there is another option called VAWA cancellation of removal. This is also called suspension of cancellation, which was enacted prior to 1996. The requirements for VAWA cancellation of removal are similar to those for when you file for VAWA directly with USCIS, except there's an additional requirement that you have to have been physically present in the US for at least 3 years, and you must show your removal would cause extreme hardship. There is one helpful factor for those who are filing for VAWA in deportation proceedings, and that is that you don't have to meet the filing within 2 years of divorcing or death of your abuser. So you can pretty much file for VAWA cancellation of removal at any time when put into deportation proceedings, as long as you meet the physical presence of 3 years prior to the deportation proceedings. If you are successful in getting cancellation of removal, you receive the same benefits as a normal VAWA petitioner, and that is receiving lawful permanent resident status. And you can also help your children under the age of 21 come into the US and receive their green cards as well. If you're facing deportation proceedings and have questions about whether you qualify for VAWA cancellation of removal, please contact our office at 832-792-3636. Make an appointment to discuss your case more fully, and we can see what your immigration options are. A final note on VAWA is that although you may have heard on the news that VAWA's funding has stopped due to the government shutdown, that just means basically that any funding for programs or shelters or some benefits for victims are currently not reauthorized for funding. But that does not mean that the immigration benefits itself for filing for VAWA have stopped. So you can continue to file for those immigration benefits with USCIS. That concludes tonight's live video on VAWA. If you guys have any questions, you can go ahead and reach out to our office by contacting us directly at 832-792-3636. You can also post your questions here under this live video or direct message us on our Facebook page at Rahgozar Law Firm PLLC. Thank you guys, and I will see you next week for another episode of Wednesday Wisdom with Pegah. Have a good night.